Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry, Smith & Frank make all the pieces fit together.
My name is Carrie Kennedy. I am another lawyer with Devry, Smith & Frank, and I do practice in the area of employment law. The subject that I've been asked to discuss today is threefold. It's holiday pay, vacation pay, and leaves of absences. These three topics are largely based on statute. I promise you I will not be reading from the Employment Standards Act to you because that would be very, very boring. I'm going to hit on a few highlights of these three areas, and hopefully many of you already know these things, and hopefully I can give you some tidbits of information that you don't yet know. So holiday pay, or public holidays are often referred to as statutory holidays. There are 9 of them in Ontario, and I've listed them on the slide for you. Holiday pay is discussed in Part 10 of the Employment Standards Act, and that's in sections 24 to 32 of the Act. Some of the key points of holiday pay are that employers must pay holiday pay for public holidays. And holiday pay is regular wages and vacation pay payable to the employee, and the Act sets out a formula to figure out what exactly the public holiday pay is, and that's a formula where you take into account what the employee was paid for the 4 weeks before the public holiday divided by 20. There are certain situations where the employer may have to pay premium pay, and premium pay is 1.5 times an employee's regular wage. If there's a situation where an employer is required to pay premium pay, you'd only pay that for the actual hours worked by the employee on the public holiday. So if they typically work 8 hours, but they work on the public holiday and they only work 5 hours, you only pay them the 5 hours worked. So if an employee does work on a holiday pay, then that employee is entitled to either the premium pay that I just discussed plus the regular pay, or they're entitled to a holiday or a day off in lieu of that particular date. If they've chosen to take a different day off, then that day should be taken within 3 months of the public holiday, but they may agree with the employer to extend that time and take it up to about 12 months later. So keep in mind, a public holiday is not a vacation day. An employer is not entitled to dock that employee a vacation day for taking the public holiday off. If an employee is on a leave of absence, when that public holiday happens, they are entitled to holiday pay for that day. And if an employee has worked on a public holiday and later gets terminated before they've taken their leave day, the employer is under an obligation to pay them for that public holiday that they did work. So my next topic is vacation with pay. This is in Part 11 of the Employment Standards Act. It's sections 33 to 41.1. And in this section, the Act distinguishes between vacation time and vacation pay. With respect to time, employees earn 2 weeks of vacation time after 1 year worked. That's a statutory minimum. Of course, employers are always welcome to give their employees more time off, which I'm sure they would all appreciate. With respect to vacation pay, the Act says that vacation pay is equivalent to at least 4% of gross wages earned during the year. So some of the key points with respect to vacation pay, vacations with pay, is that the employee must be allowed to take the vacation as either a 1 week period or a 2 week period. If they want to take it either a day at a time or 2 days at a time, they need the employer's agreement to do so. And earned vacation should be taken within 10 months of it being earned. With respect to vacation pay, employers should pay vacation pay either as a lump sum prior to the vacation being taken, or if they've entered into an agreement with the employee, it can be paid as it accrues. You just have to be sure that you're very clear on their paycheck what is their regular wages and what is their vacation pay. So an employee is allowed to waive vacation time. They can choose not to take it. There's no problem with that. But an employer is not allowed to waive paying vacation pay. You're on the hook for paying that regardless. If employment ends and there's outstanding vacation entitlement, the employer is obligated to pay all accrued and unpaid vacation time to that employee. And that should be paid not later than 7 days after the end of the employment or on the next pay date, whichever is later. One interesting tidbit outside the area of legislation is in wrongful dismissal cases. And there's been some discussion about whether employers are obligated to pay vacation pay during a notice period. So if an employee is terminated and they're told you have to pay 6 months pay in lieu of notice, are you also obligated to pay vacation pay? Some jurisdictions have said yes. Ontario generally favors no. The courts in Ontario look at that as sort of as double recovery, and in many cases have said that employers do not have to pay vacation pay during the notice period. So my final area to discuss is leave of absences, and there are quite a few of them. This is in Part 14 of the Employment Standards Act. It's sections 45 to 53. The types of leaves that employees are entitled to take are pregnancy leave, parental leave, family medical leave, organ donor leave, personal emergency leave for declared emergencies, and reservist leave. So pregnancy leave is available to employees who have worked 13 weeks or more. This is an entitlement. It can't be denied to the employee. Leave may begin no earlier than 17 weeks before the due date or on the date on which the woman gives birth to a live baby. And it can't start any later than the earlier of two dates, being the due date or the day on which the due date and the day on which she gives birth. So my due date is July 21st. So based on the legislation, I can't work beyond July 21st, even if my baby has not yet been born. Pregnancy leave ends 17 weeks after it begins. And if the woman is not entitled to parental leave, then it will end on the later of 17 weeks after it begins or 6 weeks after birth, stillbirth, or miscarriage. So if someone has already worked or taken, say, 15 weeks of pregnancy leave and then has a miscarriage, they would be entitled to a further 6 weeks after that. So like I said, pregnancy leave is a right of the employee. They cannot be denied this particular right. And it is up to the employee to decide when to take leave, and so long as they're compliant with the time frame set in the Act. The employee is expected to give 2 weeks written notice to the employer of their intention to take pregnancy leave, and the employer is entitled to ask for confirmation from that particular employee of the due date, and the employee must then provide that to the employer. If a woman is on pregnancy leave, she can end that leave early. The legislation does say she should give 4 weeks written notice to the employer of her intention to end leave early. And if an employee is on pregnancy leave and wants to terminate her employment, she is expected to give 4 weeks written notice of her intention to do so. The next type of leave is parental leave. Again, the employee has to have worked for 13 or more weeks to qualify for parental leave. And this type of leave applies to parents. And parents can be natural or adoptive parents. It can be the mother or the father. So leave can start no later than 52 weeks after the day the child is born or comes into the employee's custody, care, or control for the first time. And it may begin when pregnancy leave ends. So if a woman takes her 17 weeks of pregnancy leave, then she is entitled to roll that into parental leave following that. If a woman has taken 17 weeks of pregnancy leave, she's entitled to 35 weeks of parental leave, bringing her up to 52 weeks. If a parent has not taken pregnancy leave, they are entitled to a total of 37 weeks. So if a woman takes 17 weeks pregnancy leave and then the father of the child takes the rest of the leave entitlement, he's entitled to 37 weeks. Again, there's an expectation that the parent taking parental leave gives 2 weeks written notice to their employer before they take the leave. And again, they should give their employer 4 weeks written notice if they choose to terminate their employment while on leave. The Employment Standards Standards Act allows employees to take family medical leave. And all of these leaves that I'm just talking about right now are leaves without pay. If there is a contract of employment that signs that provides for the employer paying the employee while they're on leave, then you have to comply with your employment contract. But the ESA sets the minimums, and the minimum is to have leave without pay. So family medical leave is another type of leave without pay, and this is a type of leave for up to 8 weeks, and this is to provide care for certain people that are set on the act, like spouses, parents, step-parents, children, stepchildren, foster children. And this is to provide care for someone who's at significant risk of death, and that risk of death should be occurring in about 26 weeks or shorter. The employer may require that the employee provide them with confirmation from a qualified health practitioner that this person that they're caring for is actually at risk of death. And under this particular type of leave, leave is taken in full weeks. So if there's a death that occurs on Monday, the employee is entitled to take the rest of the week off. Employees are entitled to take time off to donate organs. This again applies to employees who have been employed for at least 13 weeks. And the Act actually specifically defines which type of organ donation applies to this type of leave. This type of leave is for a period of up to 13 weeks, but if the employee needs more time based on a doctor's opinion, it can be extended. Personal emergency leave applies to employers who employ 50 or more employees. And this is another leave without pay where the employee is entitled to look after people in time of emergency with personal illness, if there's a death or if there's an urgent matter that they need help with. And again, this applies to certain individuals that are defined in the Act and in the regulations. This is an entitlement of 10 days over the span of 1 year. Employers are entitled to require the employee to provide evidence that their leave is necessary to care for the other individual in the circumstances. The last two types of leave I don't think are particularly common. There's leave when there's a declared emergency, and this is an emergency declared under a particular act, and certain other requirements are met. Reservist leave applies to an employee who gets called away to work with the Canadian Forces. One of the differences for this particular section is the employee must have been working for 6 months to qualify for this particular leave. Some of the general provisions to keep in mind is that during leave, the employee is still entitled to participate in things such as pension plans, life insurance plans, accidental benefit plans, and the employer is still obligated to make their contributions to these plans. Even though the employee is on leave, that time is still included in calculating the employee's length of employment and service and in determining their seniority. Once the leave ends, the employer is under an obligation to provide the employee with their job back or a comparable job back. There's some issues that arise on what is comparable if their job does become redundant or phased out, like Yet mentioned. The employer is still under an obligation to provide that employee with a job that is comparable to what they had before. But if there were grounds to dismiss an employee before they left, and those grounds still exist when the employee comes back, the employer is still entitled to dismiss, like they are in any case where there is reasonable cause to dismiss them. So that was a very quick run through of these sections. Track me down afterwards if you have any questions, and I'll pass you over to Justin Lynch.